Joined by Miss Paulette Neil, an associate attorney at law at DunnCox, to help us understand our options for turning a monetary judgment into a cash compensation. Good morning, Miss Neil. How are you today?
Good morning, Richie. I am fine, thank you. And you?
I'm doing well, and we're really, really pleased that you could join us this morning to dissect a very important subject, enforcement of money judgments. I know that you're armed with a lot of information, right?
Right.
Absolutely. All right. Now, first of all, what can you do, or what can one do if they obtain a judgment in court for a sum of money, and the judgment is not actually paid?
Okay. So, firstly, if you have commenced a claim in court to recover a sum of money and you successfully receive that judgment in your favor, you are now deemed a judgment creditor. And the other party who has been ordered to pay you that sum of money is a judgment debtor.
Mm-hmm.
Now, if the judgment debtor refuses to comply with that court order, there are several options that are available to the judgment creditor to recover that sum of money.
Can you name them?
Sure. These options are known as enforcement options.
Okay.
And some of them include, you could get an order from the court to seize and sell the judgment debtor's goods. You could also obtain an order for an attachment of debt. This is an order whereby any sum of money that is owed to the debtor will be paid to you instead.
Mm-hmm.
You could also place a charge or a lien on the judgment debtor's property, and you could take steps to sell the judgment debtor's property.
To recover.
Right, to recover the sum of money owed.
Mm-hmm. Okay. So those are the full extent of options that are available?
No, there are other options available. I just listed a few.
Okay. So how does one determine which of those options is best suitable to enforce the judgment?
Well, the starting point is to assess the type of assets that are owned by the judgment debtor. So if you have knowledge that a third party is indebted to the judgment debtor, and that third party has within its custody or its control monies or goods or property that the judgment debtor has interest in, then you could apply for a court order for an attachment of debt. So, for example, if the judgment debtor has money held in a savings account, or money is held on fixed deposit, or even if there's NHD contributions that are owing to the judgment debtor, the judgment creditor could then apply for an order that these sums, which are due from the financial institution or NHD, be paid directly to the judgment creditor to satisfy the judgment.
Okay. All of this would be done with the help of an attorney at law, I'm sure.
Certainly. It would be best.
Yes. Now, my next question is, what if there is no money due and owing to the judgment debtor, but the judgment debtor owns other assets such as a motor vehicle or a house or maybe some stocks?
Okay, so if there are no monies owing to the judgment debtor and the judgment debtor owns a motor vehicle, you could get an order for seizure and sale of the motor vehicle. If the judgment debtor owns land, you could apply for an order for sale of land. However, importantly, if you're pursuing these options, it is prudent to first inquire whether there's a lien on the title for the motor vehicle or the property. Because if there is a lien on the title, then the company that has this lien on the title, they're deemed a secured creditor and they will be paid first.
Yes.
So you do not want to be in a position where you have received an order to sell a motor vehicle or a property, and at the end of it, there's little to nothing to get from it to satisfy your judgment.
Mm-hmm. Got you.
Now,
go ahead, yes.
Sorry, on the other hand, if the individual owns stock, you could get an application for a charging order preventing the disposal of these stocks, and you could also get an order to sell these stocks.
Okay, these are very important bits of information that we're getting this morning. Wow. I want to remind the listeners, by the way, that if you want to send a question in, you can send us a WhatsApp message, 876-383-1166. If you want to find for us to ask the attorney, Ms. Neil, a question on the subject enforcement of money judgments. So we continue, Ms. Neil. Can one pursue more than one method of enforcement at the same time?
Yes, you certainly can. Particularly where pursuing one method, even if you're successful, you won't be able to satisfy the judgment in full. In such an instance, you can pursue more than one method of enforcement.
Mm-hmm. And that happens. I mean, there are several cases like that.
Right. So you could get an order for an attachment of debt, like what we spoke about earlier, with getting the money that are in the judgment debtor's savings account be paid directly to you. And at the same time, you could get an order to seize and sell a motor vehicle owned by the judgment debtor.
Okay. Can we take a question from one of our listeners? Carrie Ann writes in here, Ms. Neil, and she says, what if the property of the judgment debtor is jointly owned?
Well, that is an interesting question because case law would have suggested that this property needs to be owned by the person whom the judgment has been made against. So if the property is jointly owned, you may need to, you would have to get the joint tenancy severed before you can enforce that judgment. Okay.
Carrie Ann, thank you for the question. I hope that you got the answer that you require. Now, we also want to ask you, can an individual be sent to prison for failing to comply with the judgment?
The short answer to that is yes. However, there are steps that would be required to be taken before the judgment debtor can be committed to prison. So you'd have to serve what is called a judgment summons, and at the hearing of the judgment summons, the court is going to examine the means of the judgment debtor. So if the court is satisfied that the judgment debtor has with the means to make the payment of the sum of money owed but has refused or neglected to do so, then the court may commit the judgment debtor to prison for a specific period or until the judgment is satisfied, whichever is sooner.
Okay. I can think of one more question that I really want to put on the table this morning. What if the judgment is made against a company or a partnership?
Okay, so in the case of a partnership, the judgment can be enforced by an order against a partner or the firm's property. However, a company is a separate legal entity and it may own its own assets such as property or shares or goods. So a judgment for a sum of money can be enforced against a company's property. So you could get an order to sell the company's property.
I guess the length of time that it takes to get final settlement in these instances would vary depending on what option is selected, eh? Sounds like we lost Miss Neil for a moment. Are you there, Miss Neil?
Yes, I'm here.
Yes. You're about to answer. I didn't hear the answer to the question, yes?
Yes, the time may vary depending on which method of enforcement you decide to go with.
Yes. All right. You have provided us with a lot of wonderful information this morning. I'm sure that the listeners found it to be useful as well. And we're pretty much out of time. But before you go, Miss Neil, I'm going to ask you we close out with a did you know tidbit. Do you have one for us this morning?
I do have one. It's a lengthy one, but I have one.
Let's hear it.
So, did you know that if you have not enforced your judgment within 6 years of receiving the judgment, then you may be required to obtain permission from the court to enforce it. And in applying for the permission, you would have to explain to the court why you did not enforce the judgment within the 6 years.
Did you say 6 years?
Yes.
Okay, 6. All right. Not 66 years. All right. Thank you so very, very much. We appreciate that. And we wish you a wonderful day today, Paulette Neil. Have a good day.
Thanks for having me. Have a great day also.
All right. Thank you so much. That was, of course, The Legal Landscape. We do it every Wednesday morning at 8 o'clock right here on Top of the Morning on The Edge. Today's guest was Ms. Paulette Neil, an associate attorney at law at DunnCox. And our topic today was enforcement of money judgment.